Now, previously we discussed the partner's first major obligation among themselves, which is the partner's obligation to contribute his or her share in the partnership's capital. Now we proceed to discuss the second major obligation of the partners among themselves, and that is the obligation to not engage in business for himself or herself. Now, in relation to this, please note that it is important first to distinguish what kind of a partner or what type of partner we are talking about. We must distinguish whether a partner is industrial or capitalist. And when we say industrial partner, we are referring to a partner who contributes only his or her industry to the partnership. That's according to Article 1789 of the Civil Code. Whereas a capitalist partner, by contrast, contributes money or property to the partnership, as defined under Article 1808 of the Civil Code. So insofar as the industrial partner is concerned, let us be guided by Article 1789 of the Civil Code, which reads as follows. An industrial partner cannot engage in business for himself unless the partnership expressly permits him to do so. And if he should do so, the capitalist partners may either exclude him from the firm or avail themselves of the benefits which he may have obtained in violation of this provision, with the right to damages in either case. So, to be able to better understand this provision, let us break it down as follows. So, 1789 is the provision as far as industrial partners are concerned. Now, what does the provision prohibit the industrial partner to do? It prohibits the industrial partner from engaging in business for himself. It did not specify what kind of business, but generally it prohibited the industrial partner from engaging in business for himself. Now, the provision, Article 1789, also provides the exception unless the partnership expressly permits him or her to do so. So there's an exception, there's a prohibition, and there's an exception as well, unless the partnership expressly permits him to do so. Now, in the event of violation, or if the industrial partner engages in business for himself contrary to the prohibition, then there is a remedy provided by the law for the other partners, for the capitalist partners. What can the capitalist partners do in case the industrial partner engages in business for himself? Number one, the first option for the capitalist partners is to exclude the industrial partner from the partnership plus damages. And the second option is to avail of the benefits obtained by the industrial partner in violation of this prohibition. Also, with the provision for damages. So in this case, in case of violation by the industrial partner, the capitalist partner or partners have two options. Number one, exclude the industrial partner plus damages. And number two, avail of the benefits of the violation plus damages also. Proceeding now, Article 1808, on the other hand, is the provision applicable to capitalist partners. 1808 specifically says, the capitalist partners cannot engage for their own account in any operation which is of the kind of business in which the partnership is engaged, unless there is a stipulation to the contrary. Any capitalist partner violating this prohibition shall bring to the common funds any profits accruing to him from his transactions, and shall personally bear all the losses. Okay? So breaking down this provision, we also see what the prohibition is, what the exception is, and what is the remedy available to the other partners in case of violation. So looking closely at Article 1808, we see that the capitalist partner is prohibited from engaging in operation of the kind of business that the partnership is also engaged in. So in other words, in simple terms, the capitalist partner cannot engage in business which is in the same line of business that the partnership is engaged in. Okay? Then there is an exception provided under Article 1808 when there is a stipulation to the contrary. Okay? So if the articles of incorporation, so if the contract of partnership allows the capitalist partner to do so, then there is the exception which the capitalist partner, under which the capitalist partner may be allowed to engage in the same line of business. Okay? So again, the exception is if the partnership expressly allows him to do so. And again, what is the remedy in case the capitalist partner violates this prohibition? Then, what will be the effect? The capitalist partner should turn over the profits from the transaction. But in case of loss, the capitalist partner alone will bear the loss from violating this particular prohibition under the Civil Code. Now let's discuss this case by way of an example, Evangelista and Company versus Abad Santos. Now in this case, Estrella was doing business with Domingo, Leonardo, and Conchita. Okay? Now, Estrella went to court precisely because she was alleging that she was not being given her rightful share in the profits of the business. And eventually, to make things simple, the court had to determine whether or not Estrella is an industrial partner. Now, the circumstances which are relevant to the determination of the court are as follows. Number one, Estrella, aside from being involved in this particular business, was also acting in her capacity, or was also engaged in being a judge in a court in Manila. So the court had to consider that circumstance. Estrella, aside from being involved in this business, was also a judge in a court in Manila. Now, did that affect her status or her argument that she was or she can be considered an industrial partner? The court said no. The court said that being a judge cannot or can hardly be considered or can hardly be characterized as business. So the court in effect said, or the court in effect explained, that even if Estrella was also working as a judge in Manila, that work as a judge cannot be considered engaging in business because being a judge cannot or can hardly be characterized as engaging in business. So the court said that being a judge is not a valid ground for the other partners to exclude Estrella from the partnership because being a judge is not engaging in business. Another point that the court had to consider in deciding this case is the fact that Domingo, Leonardo, and Conchita, the other partners, very well knew that Estrella was a judge when they had her admitted into the business or into the partnership. So in effect, they knew that Estrella was a judge, yet they nevertheless admitted her into the business or into the partnership. So the court in effect ruled that Estrella cannot or should not be excluded from the partnership, primarily because number one, being a judge is not engaging in business, and number two, the other partners knew very well before they admitted Estrella into the business that she was in fact working as a judge. Now, for purposes of our discussion regarding a partner's obligation not to engage in business for himself or herself, it might be helpful for us to distinguish, insofar as our profession is concerned, the concept of number one, practice of the customs broker's profession, and number two, engaging in business of customs brokerage. So to be more specific or to be meticulous about this, there can be a difference, or there seems to be a difference between these two concepts. Number one, practice of the profession, and number two, engaging in the business of customs brokerage. all we have to do, we have to look at Section 6 of Republic Act 9280. Section 6 of Republic Act 9280 defines and tells us what is included in the scope of practice of customs brokers profession. Okay? That's provided for under the law. Now, if you look, however, in Section 2 of Republic Act number 9853, which amended 9280, it seems clearer that the practice of customs brokers profession is different from or can be distinguished from engaging in the business of customs brokerage. Specifically, this can be deduced from the first paragraph of Section 2, Republic Act 9853, which says, the practice of customs broker is a professional service, admission to which shall be determined upon the basis of individual and personal qualifications. This seems to imply that practice of customs brokers profession is limited to natural persons because, again, as mentioned earlier, the practice can only be done by someone who has the necessary personal qualifications under the law. So again, the provision of the law itself says that the basis for you to be allowed to practice is individual and personal, seemingly implying that only a natural person can practice the customs broker's profession. However, looking at the provision further, Section 2 of 9853, however, nothing in this act shall prevent a corporation from being registered for the purpose of engaging in the business of customs brokerage as long as the corporation shall engage or hire the services of at least one customs broker. Now we see that engaging in the business of customs brokerage is not necessarily limited to natural persons but may also be engaged in by juridical persons such as the corporation, and by implication also by the partnership. So in other words, we now see that there is a difference between practicing the customs broker's profession and engaging in the business of customs brokerage. Okay, we now continue. We have discussed first the obligation of the partner to contribute his or her share in the capital. We also finished discussing the obligation of the partner not to engage in business for himself or herself. We now proceed to the third, the obligation of the partner to contribute additional share or to sell interest to the other partners in case of imminent loss of business. That's provided for under Article 1791 of the Civil Code. A partner is obliged to contribute additional share in the capital, or in the alternative, he or she may also choose to sell his or her interest to the other partners, okay, in the event, again, of imminent loss of business. There are, however, exceptions to this obligation, and number one is if there is an agreement or if there is a stipulation to the contrary, and number two, in the case of an industrial partner. So in the case of an industrial partner, he or she may not be obliged to make additional contribution or to sell his or her shares to the other partners in case of imminent loss of business. Again, these are the two exceptions. One is if there is a stipulation to the contrary, or number two, in case of an industrial partner, he or she does not have this obligation. Okay, the fourth obligation, proceeding now to the fourth obligation of the partner. This is the obligation of the partner to answer for damages suffered by the partnership. Now, this can be found in Article 1794 of the Civil Code, which is fairly simple and self-explanatory. So let me just read it for you. Article 1794 tells us every partner is responsible to the partnership for damages suffered by it through his fault, and he cannot compensate them with the profits and benefits which he may have earned for the partnership by his industry. However, the courts may equitably lessen his responsibility if, through the partner's extraordinary efforts in other activities of the partnerships, unusual profits have been realized.